Welcome, everybody, to our virtual webinar, Protecting the Elderly and Vulnerable During the Period of Coronavirus. I am so glad that you're able to join us today, and thank you for taking time out of your schedule to do so. Firstly, some housekeeping matters. There is a question and answer box to the right of your screen. If you have any questions, please do type them into that box and we will deal with them at the end. And secondly, the event is being recorded, so just to let you know that, but also I understand that there will be a recording sent around afterwards so that you can re-listen. My name is Kelly Gregg. I'm Head of Later Life Planning at Irwin Mitchell, which means that we deal with all issues affecting the elderly, but also planning for later life and making sure that people have their affairs in order so that there is no undue stress in the later life years. I'm joined today by Stuart Stretton-Hill, who is a Senior Associate working with me, who specialises in legal affairs affecting the elderly and in mental capacity. And we are delighted to welcome Allison Heskis of Time Finders. Allison is a Director of Time Finders, which is a Senior Life Specialist. Allison established Time Finders in 2010 after helping her own mother to downsize and settle into a new community. Time Finders bridges the gap between the legal and financial professions and the care sector by providing practical help and emotional support to older people and their families in changing circumstances. Time Finders also work with clients both in their own homes and in residential care. Many of their clients are aging alone without family to support them. Can definitely concur with that, and in particular, those living with dementia, to make sure that their best interests are protected and that decisions regarding care and treatment are respected. So, the agenda for today, we're going to go on for about an hour. Firstly, Stuart will be discussing the challenges faced by attorneys and deputies in complying with their duties during this period of lockdown. Then Alison will be discussing the emotional and practical issues that we're all facing and encountering during lockdown for those that require care. And finally, I will be discussing the impact on the care sector. After we finish speaking, we will have a period of time for questions and answers. So please do, as I said before, put your questions in the Q&A box on the right of your screen. So, firstly, Stuart.
Thank you very much, Kelly. Hopefully everyone can hear me okay. Yes, one of the best ways I'm sure all of us know for the elderly and vulnerable to protect themselves is to make a lasting power of attorney far enough in advance. I would say both for their finances and certainly for their health and welfare. For those who aren't familiar potentially with lasting powers of attorney, through a lasting power of attorney, someone can appoint another individual that they trust to make those very personal decisions about their care and their finances for them. I should, of course, mention that if someone wants to make a lasting power of attorney, they need to have the requisite mental capacity to do so. And unfortunately, people often leave it too late. And so family members or indeed anyone else who is interested in the individual estate is left, sadly, only with the option of applying to the Court of Protection to be a deputy, which is essentially a court-appointed attorney. Deputyship orders are often much more restricted than the authority an attorney gets under a lasting power of attorney. Attorneys and deputies both have very, very strict rules with which they must comply when acting for an individual who lacks capacity, and they must always adhere to the 5 overriding principles which are set out at the very start of the Mental Capacity Act. And I think that just shows how important the government feels that these principles are. And again, I'll quickly run through those for everyone who might be unfamiliar. The first principle is that the individual must be assumed to have capacity unless it's proved otherwise. The second principle is that an individual mustn't be treated as incapable of making a decision unless all practical life savings and blow them on the 1215 at Kempton Park, they're allowed to do so, provided they understand what the consequences are. And very, very importantly, an attorney or deputy acting must always act in the individual's best interest. And I'll come back a lot more to best interest as I go through. Finally, before an attorney or deputy does something for the individual, they must make sure that the outcome could be achieved in the least restrictive way possible. A classic example of that is if an individual might need care, an attorney should look at care options of perhaps providing care for the individual at home rather than just saying, right, straight off to a care home with them. Because obviously a care home is a very restricted environment. Now, those principles obviously impose some very significant duties on attorneys and deputies, and despite the COVID crisis, those duties have not been relaxed. Although it's not necessarily practical, my personal view is it's correct that those duties haven't been relaxed. They are there to protect the most vulnerable in our society, and the COVID crisis is a classic opportunity for the unscrupulous to take advantage of elderly and vulnerable individuals. So personally, although it might be difficult for attorneys and deputies to comply, I'm delighted those restrictions haven't been relaxed. I'm going to look at two things today, as Kelly said, the difficulty for attorneys and deputies to comply with their duties, but I'm just going to very, very briefly touch on the issues of making a lasting power of attorney. I think it's very important that we encourage individuals to still make power of attorney even during this crisis. It's still possible to do it, even with social distancing in effect. And indeed, for those who might suddenly fall ill from contracting coronavirus, it's very important they make sure they've got a power of attorney in place before that happens. Provided the individual's got mental capacity, it's not too late. They can still do it. There are some practical issues to making powers of attorney. The donor of the power of attorney must have a witness. They must have someone who is going to sign the document against their signature. And they must also have a certificate provider who's the individual who confirms the donor has capacity to enter into the power of attorney. Witnesses must be physically present. You can't witness a document over a video or a Skype call at the moment. So that presents obviously some challenges, as elderly and vulnerable are more likely to be shielding, self-isolating. How can you act as a witness? I'm pleased to say there's some really useful guidance on the Gov website about how to act as a witness. The important thing to take away is you must have a clear view of the individual who's signing the lasting power of attorney and be shown the completed signature immediately afterwards. Everyone must sign and date the same document, but that doesn't necessarily mean you can't have pages separate at the time they're being signed, provided they're all in the same physical locale. After the donor signed, a certificate provider must sign. There is no requirement for the certificate provider to be in the physical presence of the individual. They just must be satisfied that the individual does have capacity, and that could be done via a video conference or indeed telephone call. And then the certificate provider can sign the document after the donor. And then finally, the attorneys must sign. They must also have witnesses. Same restrictions apply. Attorneys cannot be witnesses to the donor, but they can witness each other's signatures. So if you've got a husband and wife living together who are both attorneys for another person, another independent individual, they could witness each other's signatures. My personal view is it's better to have absolutely independent witnesses, but obviously we are in trying times. If attorneys have to witness each other's signatures, then that's fine. After everyone's signed, the document needs to be registered with the OPG, the Office of the Public Guardian, before it can be used. The OPG's timescale before COVID was 6 to 8 weeks for registration. It's now up to 8 to 10. I think that's a bit optimistic. It's probably taking longer than that. So my view is, if you know anyone who hasn't made a lasting power of attorney or is dithering about it, go ahead, get it done. It's better to get it in place and to have someone you trust making those really important financial and health and welfare decisions for you. And just because of COVID, just because of social distancing, it doesn't mean you can't make an LPA. You can do it. Just be a bit cautious, obviously, about complying with the social distancing rules. So if you've got an LPA in place or you've got a deputy appointed, how are they complying with their duties? Well, I said earlier they've got some very strict responsibilities. They've got great responsibility if you're an attorney or a deputy. If, as an attorney or deputy, you fail in your duty, you can be personally liable for the loss suffered by that individual, by their estate. And indeed, you might find yourself liable to third parties, such as beneficiaries under a will. The classic example is where a deputy or an attorney gives away or sells an asset that is specifically left to someone under the donor's will, that beneficiary who's now disappointed can come back and challenge the attorney or deputy personally for the value of that asset. So it's essential that attorneys and deputies first understand their duties and secondly comply with them. And one of the major problems is that, you know, if you signed a power of attorney, you may have done it years ago, had no real clue what you're taking on as an attorney. And one of the things we're pushing very much forward at the moment is education of attorneys and deputies on their duties. We have a set of later life services that we offer, the slides are on screen there, which are all about helping attorneys and deputies understand their duties, help to comply with them before it all goes horribly wrong. So in this current environment, what are the challenges? Well, I mentioned best interest earlier, and attorneys and deputies taking decisions in best interest. It's not defined in statute unhelpfully, but over the years, through case law, it's come to be accepted as a balanced use approach. The attorney or deputy must think about the decision they're taking, weigh all the pros and cons, and throw into that what are the donor's wishes, what are their past actions, what are the views of family members, what do carers think, what's the impact on the donor's freedom, and then having thrown all that in together, weigh up the pros and cons, and then take the decision or not, depending on whether they feel it's in the individual's best interest. The sum of that comes with the duty of visiting the donor to check on their welfare, discussing with them the decisions that need to be taken, and potentially assessing their capacity as well. Capacity is not black or white, as I said earlier. It's dependent on the decision being taken in question. So what if the donor, what if the individual subject to the deputyship order is self-isolating or shielding? How can an attorney or deputy comply with those duties? Well, I'm pleased to say again, the OPG, the Gov website is really coming through. There's lots of helpful guidance on there about how attorneys and deputies can comply with their duties. I think first, it's important to realise the attorney's not necessarily required to see the individual in person to assess their capacity. So it could be done by video conference or possibly liaising through a third party, a trusted third party such as a carer. The key thing is that whatever method the attorney or deputy uses, it's essential that they are satisfied that the individual doesn't have capacity, bearing in mind the principle to assume that they do to start with, before they take the decision in question. If it's not possible at all to visit, to have a video conference, liaise through a carer, an attorney or deputy can still carry ahead with the decision-making process, but they've got to really carefully document it, really carefully say why they feel the individual doesn't have capacity and why the decision they're taking is in their best interest. That involves taking into account their past actions, the wishes and views of the donor. So it's not ideal, but if possible, whilst complying with social distancing, an attorney or deputy should try and visit the individual to obtain their views, to assess their capacity. Where a decision is being taken without a visit, without speaking to the donor, then best practice would be to go back after the decision has been taken, when COVID has calmed down, when the social distancing is relaxed, to revisit that decision and make sure it is still in the donor's best interest. Secondly, think actually whether the decision needs to be taken straight away. If it doesn't need to be taken immediately, leave it. Wait till social distancing is relaxed. Wait till the individual is out of the risk period, and then go and visit them and talk to them about the decision you want to take and discuss it personally. It's much better to have a well-documented decision that has been discussed than to just press ahead and hope it will be okay. On the point of assuming capacity, if the attorney has doubts about the individual's capacity, and feels like they can't assess it remotely via a telephone conference, then there are professionals out there who will undertake assessments. There's great companies like TSF who can do assessments. And again, it's better for an attorney to seek a professional assessment of capacity if they're in any way uncertain, particularly if it's a major decision. If they're selling a property or taking a decision to move into care, an attorney or deputy is going to want a professional capacity assessment in place to back up that decision in the future. What if it's the other way around? What if it is the attorney who's self-isolating or they're too ill to act? Can they ask others to take on their duties or to temporarily cease acting? And the very short answer to that is no. I know it's slightly unusual for a lawyer to sound so definitive, but that is the case. Attorneys cannot temporarily disclaim their powers. It's an all or nothing deal. If they do disclaim, if they do retire as an attorney or renounce or try and put a temporary pause on what they're doing, then the replacement attorney, if any's been appointed, will step up. If there's no replacement attorney appointed under the LPA, it'll cease to have effect. So it's very, very important that attorneys think very carefully about ceasing to act, about renouncing or stepping down. Attorneys can't delegate their decision-making powers either unless they're specifically allowed to under the power of attorney. But there's nothing to stop an attorney employing or asking someone to implement the decision they've taken. So, there might be the decision, does the donor require care? Well, that is the decision being taken by the attorney. The implementation of that care can be delegated to a care agency. Obviously, the attorney still needs to liaise about it, but as I said, the decision is taken by the attorney, the implementation by an agency. Again, it's also important for the attorney to retain control of the individual's finances. In the same way, they mustn't delegate their powers. So if the attorney is isolating, can they do shopping for the donor? Well, yep, online is an obvious example, but we know all the challenges there about actually trying to get a delivery slot booked. And I appreciate all the difficulties the supermarket's going through, and bravo for their efforts. But in practice, is it possible to get a delivery slot? What an attorney shouldn't do is hand over a bank card to a carer or third party and say, go off and do the shopping, because they are losing control of the individual's finances there. What they can do is get a third party to purchase the shopping for them and reimburse them out of the donor's funds, provided expenses are reasonable and they've checked the receipts. Or a better answer may be to purchase a shopping card, which can be topped up with the donor's funds, and then carers or a third party can use that to buy the shopping for them. That very much comes back to the point that attorneys and deputies are at risk of personal liability if they breach their duties. If they do something or want to do something that's not authorised by the LPA or the court order, then they need to get authority from the Court of Protection. The other issue as well is certainly with mention, I'm sure Alison will chime in on this a little bit as well, that the challenges of individuals not being aware of the social distancing limitations because of their lack of capacity. What if they aren't aware of COVID? What if they aren't aware of the need to self-isolate? Can they be prevented from leaving their property? And, well, in short, no. The deprivation of liberty safeguarding requirements mean you can't put someone under lock and key unless you have court authority. And we're actually dealing with this particular issue in a difficult case at the moment, where it's a lovely lady living on a retirement complex, very poor short-term memory, but very physically ill, very physically determined, very mentally determined, no understanding of her condition, no understanding at all of the COVID crisis. And the problem is she will go wandering at night. She's convinced her late husband is living with her neighbour, so she's round banging on the door and trying to get in, and she's bothering the estate manager with all sorts of questions at all times of day and night. Obviously, she's placing herself at great risk there of contracting coronavirus. She's putting others at risk, not least of which is she's wandering at night, other physical dangers. So an obvious solution there is she should move into a care home. There, she's contained, she can't wander around, but we've got to give consideration to not restricting her freedom as far as possible. And a move into care is unnecessary. She's perfectly able to live at home. The other factor we can put in there as well is the spread of coronavirus in care homes is significant, despite all the wonderful efforts they're trying to stop the spread. Care homes are badly overstretched as it is, and our client would put at greater risk if she were to move into a care home. The solution we've come up with is a live-in companion, not a carer, but a companion who can encourage her not to leave the property, have a chat to her, distract her from her need to go outside, and if she feels like she must go for a walk or go outside, then they can accompany her to make sure she complies with social distancing. So it's a solution there that's working quite nicely. It's been in her place a couple of weeks, and she's not thrown the companion out of the house yet. So we're quite hopeful that that's going to continue, and she will remain safe. As I mentioned earlier, the OPG has issued guidance. The Gov website has some very good guidance on attorneys and deputies as to how to comply with their duties during lockdown. I'll just summarise really by saying that attorneys and deputies do have a whole host of duties. I've only touched on a few there. Most attorneys and deputies are completely unaware of what they should and shouldn't be doing. It's all about education. I've mentioned the packages earlier. We offer these services to help educate deputies and attorneys to understand what they're doing. And we can offer practical advice as well as to how they can comply with those duties during this virus outbreak. Thank you very much. Back to you, Kelly.
Thank you, Stuart. And I think something definitely to take away is that individuals should be encouraged to think about whether they accept the role of an attorney before they really understand what it entails. And one of the points Stuart made was about there isn't a relaxation of the rules in this crisis. And I know, acting as an attorney for many clients, I did contract COVID. I was ill for some time, but I was still expected to comply with all of my duties. Luckily, I had a good team around me, but you are still expected to keep everything going for that individual. So it's really, really important that attorneys don't just sign that piece of paper. They understand what they're getting themselves in for. So next up, we have Allison, who is going to talk about some of the practical aspects and emotional aspects that she's been encountering recently. Allison.
Thank you, Kelly. Yes, so I'm going to look at some ways in which we can deal with the physical and the emotional isolation that's been brought about by COVID-19. But before I look at ways about how we can keep connected, I just want to look at some of the aspects of decision-making, because that is something that we've had some concerns about during lockdown. So if I start by who can make decisions, under normal circumstances, a decision about care or treatment would be made by the individual themselves if they have capacity to do so, or if they've made an advanced decision directive. If neither of those are there, then a decision is taken by a health and welfare attorney. If there's no health and welfare attorney, then the decision has to be made by what's called a best interest panel. And that panel is usually the medical practitioner. It's somebody who knows the resident. I say this is a resident in a care home, who knows the resident well, which might be a carer rather than a care manager. And it would be possibly a family member or somebody who knows the person well. But these are not normal circumstances, and we're aware that some of the principles of best interest decisions are not actually being always applied. So it's not my intention here to go into the whys and wherefores of that. There are going to be a lot of questions to be answered after this immediate crisis is over, and hopefully that will lead to better practice in future. But right now, we need to make sure that the right decisions are taken by the right people. So what about next of kin? The term next of kin actually has no legal definition in English law. If you're a partner, a husband or a wife, a son or a daughter of somebody in residential care, you actually have no legal right to make any decisions about that person's care unless you are their health and welfare attorney or that person has appointed you as an advocate. That's sometimes very difficult for people to understand, and it can cause a great deal of distress when people don't realise. This comes back to Stuart's point of why it's essential that people make health and welfare LPA when they can. So under normal circumstances, most care homes, most medical practitioners will, of course, recognise the role of the next of kin. It can be fraught with danger because there are very often more than one next of kin. So if you've got siblings who violently disagree with each other about a course of action, then which next of kin does a medical practitioner or a care home take? Which decision? Again, it's planning in advance to avoid these problems. An advocate is somebody who has less legal power than a health and welfare attorney, but they do have more of a right to attend those best interest panel decisions. And an advocate can be a family member or it can be a professional advocate. You can only actually be involved in somebody's care and the decisions about their care and their treatment if you actually know what's going on. And whilst we understand that care homes particularly are under the most astonishing, unbelievable pressure, they still have a duty to keep you informed. many care homes have been keeping the families and advisors of their residents generally informed about the conditions in the care home. Some of the best examples we've received have been very candid, very open. The levels of PPE that people have got, what they're doing to screen staff members, what they're doing to screen residents, what they would do if a resident actually gets COVID, how they would barrier nurse, what they would do if more than one resident gets it. Some care homes haven't given any of that information at all. And that, I think, has led to many questions and many fears being raised in people's minds. And it's actually quite easy to do through a general blind copied email or even a group text message. The most important thing, particularly in this crisis, is that you need to make sure that you're going to be informed as soon as your relative shows any symptoms of COVID-19, because only then can you actually be involved in the care and treatment decisions. And I just want to talk about end-of-life care as well. In the Department of Health and Social Care's COVID-19 Action Plan, which I think was published in the middle of April, it stated very clearly that visits at the end of life are important, both for the individual and for their loved ones, and should continue. We've had some very distressing reports of the failure to implement that instruction. And this is particularly the case for residents who are dying of causes other than COVID-19, where family members have been prevented from visiting at all. Some have been prevented visiting at the last moment, just stand outside a window, but there's been very little help to help the person inside get closer to the window and move the bed. Some have been allowed to visit right at the very last moment, wearing full PPE, but they're not allowed to touch or hold the hand of the person who's dying. But some care homes have been able to manage end-of-life visits, and we need to promote the fact that this is happening and to encourage best practice. Relatives have been allowed to visit with full PPE on many days when it's known that their loved one is dying. Some have been allowed when they're in the room to remove their mask so that they so they can hold a hand and so their loved one can see their faces. And that's been incredibly important. We have to understand that there are going to be a lot of people who have been very distressed and damaged by the fact that they are not being able to be with their loved one right at the very end of their lives. I just want to read something which actually moved me quite a lot. It's actually from the President of the Royal College of Physicians in Scotland, and it was a part of a call to the Scottish Government to permit end-of-life care, end-of-life visits. And he said, I'm just going to look over here to read at the moment because I can't remember all this off by heart. Decisions regarding the presence of family at the bedside of their dying relatives are not simply matters of infection control, and we should not permit them to be such. They are matters of our humanity, matters that define who we are, our understanding of what life is, and how our lives must end. We know how we will make people feel if we unnecessarily prevent them from being with a loved one at the time of their death. We do not need to make them feel that way. We can find ways to allow families to be together at this time. With personal protective equipment, social distancing, and isolation, family members can balance the risk to themselves and others, just as the caring professions do. So this is something that we're all going to have to fight for. COVID-19 is a virus, and we know how it spreads and we know how it's killed. Carers and care home managers are going to need our support and the support of the care home owners, as well as the direction of policymakers and the oversight of care home regulators to ensure that people we care about do not die alone. But keeping connected is not just about end-of-life care. It's about much more. And whilst I might take against the notion that visiting people in care homes is unnecessary or non-essential, actually those visits are essential. They're essential for protecting, for promoting, for preserving the mental well-being of residents in care. And we know that mental well-being is very closely related to physical well-being. So we deny them this contact at their peril. So how do we keep in contact with the ban? Many of the ideas that I'm going to come on to now are for people who are living with dementia, but everyone is an individual, and what works for some people is not going to work for anybody else. But these are some of the things that have worked for us. And I'm going to go through the 5 senses. I'll cover social safe visiting later. First thing to say is that not many care homes have Wi-Fi universally available to their residents, and this is something that COVID-19 is going to change, and change for the better. In desperation, many people have bought tablets, iPads for their relatives so that they can make video calls via Skype or via Zoom, various other programs. One of the difficulties we found is that residents, particularly those living with dementia, and they're not familiar with video calling, have found it very difficult to connect with the person at the other end of the video call. And it's actually caused quite a lot of frustration, a bit of anger, because they can't actually grip what's going on and why this person is suddenly appearing in their room. So we found it easier sometimes just to deal with old-fashioned telephone calls. Some residents are extremely private. They don't actually want anybody to see them. You know, they haven't had their hair done for a while. They may not be looking their best. They are very comfortable with the idea of telephone calls, and they would prefer to keep it that way. Thank you very much. So respecting how people think about this is crucially important. But whether or not your relative can manage telephone or video calling, helping to stay connected using tangible objects can help, and it can give you something to talk about. Obviously, if your relative has a sight impairment, then you're going to have to adapt what you do to make something relevant to them. But we found that old-fashioned handwritten letters, including photographs or bits of the news, articles from the newspaper on cheerful subjects, photographs of happy family gatherings, have been very well received. Scrapbook pages, you don't want to send an entire scrapbook, but if you do the odd scrapbook page of things that your relative was interested in, you know, whether that was train spotting or knitting patterns, pub signs, gardens, whatever, you know, the football teams from their youth, you might have to do a bit of homework, because what we found is that some of our clients with dementia have the most phenomenal memory of who scored what, when, and where, and was the ref blind or not. So it's worth doing the homework. Coming on to hearing, it's generally recognised that hearing is the last sense to disappear when we become unconscious. So even if somebody doesn't appear to have any recognition, they may still be able to hear. Again, many people in residential care will have a hearing impairment, and so allowances are going to have to be made. We also accept that many people living in residential care don't have a telephone of their own. If your relative can manage a mobile phone, that's brilliant. If not, and you have to rely upon using the care home's phone, and you have to rely on finding a carer who's got time to support your relative, that can be more difficult. Again, we found care homes who set up a regular rota so that every relative has the opportunity to talk to residents on a regular basis. You have an appointment, it's time. And that proved very, very beneficial for making sure that people keep in contact. If your care home, your relative's care home, isn't doing that at the moment, it's well worth asking whether they can set that up. And our relatives need constant reassurance, particularly, again, those living with dementia. But only it's reckoned about 70% of people in care homes have dementia. And that can be mild, right the way through moderate to advanced dementia. But they all need constant reassurance that the reason we're not visiting is because we're not allowed to. It's not because we've abandoned them or that we don't love them anymore. It's because we're not allowed to. And we are always constantly saying that we can't wait to visit. As soon as restrictions are lifted, we're going to be there like a shot to be with them. as soon as we can. Even if we have to practice social distancing, we will be there, and hopefully it won't be long now. Having telephone calls is great, but some people really struggle to find things to say. You can only say, "Isn't the weather lovely?" so many times. Again, what we found is that if you have tangible things in front of you to talk about that you could share, it's much, much easier to have a conversation and to get drawn into all those sort of tangible things that come up when you're having a really good conversation. We've been sending puzzles to some of our clients that we can do together. So we have the same word search, we have the same crosswords. I'm useless at cryptic crosswords, but you can share the clues across the telephone. If your relative likes word games, introduce them to bananagrams. You come across bananagrams? Brilliant. It's like Scrabble, but it's without the board. You can each have a set, and you can do sort of timed challenges to see who can come up with the longest word. You know, what does your relative like to do? I've been completely delighted to find that old technology still exists, and you can still get an old-fashioned cassette tape recorder. You know, the little flat ones that have the cassette that goes in at the top and the large buttons. You know, a very clear red one for off and another one and a green one for on. Can you make a recording? Can you make lots of recordings and send them regularly, week after week? The sound of familiar voices is immensely reassuring, whether you're reading an article from the newspaper, reading a poem, reading a bit from a book. These tapes can be listened to over and over and over again and provide a huge amount of comfort and reassurance that you're still there, even though you're not there. The next one's a bit odd, really, but the sense of smell, psychologists believe, is most closely linked with memory. I think we probably all get that. You know, you smell the first bonfire of the autumn, and it brings back all those memories of childhood. And this is probably more so than any other sense. So smell is really important. Do you wear the same perfume? Do you wear the same aftershave? Or use the same soap? If you do, then maybe you can, I don't know what the word is, imbibe, no. Infuse, that's the word. Infuse a handkerchief with that scent and send it to your relative so that, again, they can have that tangible feeling that you're there. Some of our clients have told us after they've lost somebody that they've loved that they've hugged their dressing gown or they've hugged their jumper because that has their smell. And we all smell, you know, whether we wash regularly or not. And that can bring a connection with somebody that nothing else can. So ignoring the sense of smell, we're perhaps denying people that opportunity of a connection. Just on a safeguarding or a safety note, coronavirus is dependent on moisture to survive. So whatever you do, make sure that that piece of cloth is dried out fully. Probably pack it in a paper bag for at least 24 hours before you send it. Because again, research has shown that the virus can live on a porous surface such as cardboard, and people equate material with cardboard for about 24 hours. And just check with the care home, just make sure that they know what safeguards you're taking as well. Sense of taste is a bit more tricky. If you live close to a care home, then yes, take along some freshly baked cakes and biscuits. Check with the care home first, make sure that whatever you're providing is suitable for your relative, for their diet, for their ability to swallow. And maybe try to do some recipes from their youth. I mean, I don't know when it was that the universal brownie entered our larders, but what about going back to the old-fashioned rock buns or raspberry buns, Gainsborough tarts, Bakewell tarts? Even better if the recipe is in their own handwriting and you can take a copy of it and include it in there, or their parents' handwriting. You know, many people do develop a sweet tooth as they get older, and but some still really love, you know, savoury things. So at the risk of alienating half of the audience here, I would suggest that cheese and Marmite World are a brilliant, tasty snack. However, other people may prefer a drink of Bovril or chutney. So I can see my fellow panellists sort of going, ah, This is awful. Anyway, if anybody wants any recipes, I can provide them later. Nothing can replace human touch. And I think this is where we've all suffered from not being close to the people we love. It's the hardest part of surviving COVID-19 restrictions. So I just want to explore some ways in which we can get together at a safe distance, in a safe place, to keep some sense of connection. And I come back to this point that isolation is damaging, very damaging to people's mental health and their physical health. So we have to urgently find ways of finding sustainable ways in which we can be connected with people in residential care. We've got also to accept that some, by no means all, but some care home managers who are desperately under pressure, desperately stressed, not always terribly well supported, are going to be risk averse. It's much, much easier to say, no, don't do anything. I've got this place safe. I'm not going to risk anything at all. So it's going to take a lot of time, it's going to take effort, and it's going to take planning. And we're going to have to help people to do that so that we can get to see our relatives. We have to be proactive and supportive, constructive and supportive. Several care homes I've seen, you may have seen in the press, have instituted these drive-bys where they sort of line all the residents up outside the home and families have been allowed to sort of slowly drive past in their car. And, you know, the news reports have been very favourable. But a number of people have said how this could almost increase the feeling of isolation because you don't have time to stop, you don't have time to chat. It's brought even more tone to you that you can't touch, you can't connect with the person. But if we can get people outside a care home to wave at a car going past, we can get people together. We've got the most wonderful opportunity right now with the warm weather to practice safe distancing in the open air, which all the medical and scientific advice says is the right thing to do to stop the spread of the virus. We can make arrangements to talk through an open window. If hearing is a problem, we can get a fairly inexpensive two-way baby monitor. And, you know, care home residents can perhaps be helped to have a chair close to the window. We can still be at the right distance. If residents don't have a room on the ground floor, then care homes can create a visiting room where residents can go and relatives can sit outside. You know, we're probably going to have to accept that free and easy, unrestricted access to care homes is not going to be around for some time to come. We're going to be visiting by appointment. And social gatherings are a brilliant way of raising the spirits. And we've demonstrated that we can come together in a safe way. We do every Thursday evening at 8 o'clock for a clap for carers. We can do that in a care home garden. Some of our clients have actually arranged coffee mornings on a Sunday morning in their street where they all take their deck chair out and their flask of coffee and they sit and they shout pleasantries across the road to each other. Now, most care homes have a garden. Most of the gardens are accessible without going through the care home. So you can get a 2-metre strip roped off with residents on one side and socially distanced relatives on the other. But looking and not touching is really difficult. The urge to touch and to hug is such a powerful urge. So just a couple of suggestions. There's a lot of care homes have the big physiotherapy board that you can kick backwards and forwards. There's some connection between you. Better still, can you bring a long piece of ribbon and can your relative have a long piece of ribbon that you can tie together in no man's land? You can have that physical contact of feeling the pressure of the pull of somebody. It's not the same as having a hug, but it is some tangible touch that you can have with them. A care home in the Netherlands has introduced a sort of a glass bubble so that relatives can sit indoors in inclement weather with their relative on one side and them on the other. It maybe reminds me a little bit of those sort of American cotton movies where you're visiting somebody in jail, but in a care home setting, I think it's going to be a lot more pleasant. Whatever it is, it's going to take planning and it's going to take effort. It's going to take perseverance and probably a good dollop of a sense of humour. It's going to take a great deal of willingness to work together. And above all, it's going to take a can-do attitude. But the protection, the preservation of every resident's mental well-being is paramount. And the rewards are going to be amazing. So I'll hand back to Kelly now. Thank you.
Thank you, Alison. Can I just remind people, if they do have any questions, to put them in the Q&A box, which is on the right-hand side of your screen. I'm just going to do a really, really short bit on what we're seeing in the care homes. A lot of the content has been covered by Alison already, so that saves me having to talk for so long. And then we will just go through some of the questions. We have had some questions already, but if you do have any more questions, please do put them in the Q&A box. So clearly, the care homes are under immense pressure. We have seen care homes that were struggling financially before the coronavirus, who are now really, really feeling the pressure. And I, unfortunately, would not be surprised that if some of them cannot continue to operate due to the costs involved. We are seeing surcharges, for example, on care invoices. So there'll be a PPE surcharge, and that might be a fixed fee, or it might be an increase in the level of the fees, like a 3%, 4% increase, for example. We are seeing increases above the usual rate in annual reviews. So we're at the time where care homes review their fees, and where we might have seen a 3% increase previously, we are now seeing 6, 7, 8% increase in fees due to the financial viability of running that home. We're also we're seeing some really good examples of care homes are doing, where we've seen the residents' lounge be turned into a dormitory for care support workers, so that they can isolate from their families and basically stay in that care home 24/7 to look after those residents, and that has got to be commended. We are seeing them try to do everything they can to ensure that there is that relationship kept up with family members. So Alison's already mentioned things like Skype, Zoom, FaceTime. Some of our residents were doing that previously because their relatives lived further afield. And so for those clients, that's continued, and they've been okay with that because that's exactly what they're used to. We're also seeing increased telephone calls, but there is definitely a confusion with the residents, especially those with dementia, because they really don't understand what's going on. They don't understand what coronavirus is. They don't understand social distancing. All they know is that they were having their family members visit them, and they no longer do, and that makes them sad. And I've heard from some family members comments like, well, so-and-so's got dementia, so they don't remember when I visit anyway, and therefore it doesn't matter. Well, it might be the case that they don't remember that you visited, but what they do remember is the feeling that they felt when you visited. And so if you visit, they will feel happy, and that feeling of happiness will continue through the day. Whereas if they haven't had that visit, they don't get that feeling. And so it's not so important they remember specifically who came to visit, or if they had that call, or even what you talked about. So Alison made the point about things you can talk about on the telephone. It doesn't really matter what you say, as long as there is some sort of contact that they can feel like they matter, and that's really, really important. One of the things Alison and I were talking about a couple of days ago was the fact about that all unnecessary visits had been stopped, and we both argued that actually a lot of those visits were not unnecessary visits. They were very much necessary, and we have seen a huge number of deaths caused just because people are not getting those visits. I always say people are dying of loneliness, but in reality, that is what is happening. They're just giving up. And so it's really, really important that we keep that contact with those people. I mean, some other things that are not particularly great. We've had care homes refusing to provide PPE to the carers. They've got to provide their own. Clearly, that's not great. I've mentioned about the financial struggles. We've had some residents having to self-isolate in individual rooms, and so they're not getting any interaction at all. That's not positive, and we need to look at ways to overcome that. And we've had a number of residents that have died where their deaths are having to go to inquest because the doctor is refusing to come to the home to certify the death. And that has unfortunately prolonged that grief for the family because they aren't able to just get on and mourn for that loss. They have to go through that inquest process. The other thing, as Stuart's mentioned as well, finally, is that residents that are not under a deprivation of liberty standard authorisation can leave at any time. And we need to manage that as well, because clearly we don't want them going out onto the street. But at the same time, if they're wanting to leave, we can't stop them. We know that there's a backlog for those that require a standard authorisation. The court have a massive backlog of those at the moment, but it is worth bearing in mind that you can't just force someone to stay where they don't want to be. So I hope that's helpful in respect of the care homes. I'm now just going to open up to questions. I've got a few, and somebody has just posted something. Okay, so my first question is probably for Stuart. What if two attorneys disagree to a course of action?
Yes, a situation I've come across a few times in advising attorneys. Funny enough, it's normally siblings. They can't agree what's best for mum. What on earth does the person who's on the receiving end of the attorney's decision do? So whether it's a financial advisor or a bank or a care home, what do they do? Well, I mean, the first thing to do is to look at the power of attorney itself. How are the attorneys appointed? I mean, if they're appointed jointly and they can't agree what they're doing, then no action can be taken at all, because jointly appointed attorneys must act together. It's trickier where the attorney's appointed jointly and severally, because they can both take in decisions on their own. And if a financial advisor or whoever is receiving conflicting decisions, whether that's to, say, purchase an annuity, there was a particular case I dealt with where one attorney wanted to buy an annuity, another one hated them and didn't want an annuity purchased. In that situation, actually, I visited the donor of the power myself and did an assessment of her capacity. And actually, I felt she had capacity to decide to purchase an annuity. So there, her decision as the individual overrides whatever the attorneys might want to do. She's got capacity to take the decision. Obviously, where the individual doesn't have capacity and do disagree, really, it's an application to the Court of Protection to try and get a court order as to what is actually in the individual's best interest. And I'd say anyone who's faced with two attorneys giving them differing instructions would be well placed to say, look, go away, take a decision between you. If you can't, then one of you come back with the court order confirming that the action you want to take is in the individual's best interest. I think the problem is people always want to appoint family members as their attorneys. They know them, they trust them, they think they're going to do a brilliant job. But often people forget the personalities involved. I look at my own children, admittedly they're only 6 and 3, but the amount they disagree, I cannot imagine them possibly agreeing over my future financial affairs. So the thought of appointing an independent third party who can take that step away, not have their own beliefs or agenda in place, and genuinely take a decision in someone's best interest could well be a better starting point. I hope that answers your question, Kelly.
Yeah, no, that's very helpful, Stuart. So just I've got time for one final question. So, Alison, my father doesn't have capacity to make a health and welfare LPA or to appoint an advocate. What can I do to make sure I am included in care and treatment decisions?
Sorry, Kelly, I missed some of that.
Sorry. Said, my father doesn't have capacity to make a health and welfare lasting power of attorney or to appoint an advocate. What can I do to make sure I am included in care and treatment decisions?
First of all, be in contact with, if this person's father is in a care home, then presumably you're already in contact with the care manager. You may well have been asked to sign a care plan. Many care homes do ask people who don't hold power of attorney to sign off care plans for people who don't have capacity, even though they're not really supposed to do that. I would say just get a very good relationship, the best relationship you possibly can with the care home manager and with the carers who are looking after your father. Make sure that you, again, this is possibly not under COVID-19 restrictions, but where a GP is visiting the care home regularly, make sure you're there, that you get to know the GP as much as you possibly can. Try and write down whatever you think your father might have wanted. Doesn't have any standing in law, but it can be used as a guide. And then just try and try. You're to a degree powerless, but you have to try to make sure that you're informed every step of the way. Some people might inform you, but then not want to include you in the decision-making process. And I would always suggest being very positive, very constructive, relentlessly polite, because you don't get anywhere by making enemies. And that's the hardest thing of all, I think, because it is such an emotional thing. And this is somebody you care for and you love and you want to be there to protect them. And your first instinct is to fight like mad for them. But softly is the way to go. Just keep getting yourself involved as much as you possibly can. And that's all I can say, is just to say, make your own health and welfare RPA. Get everybody else to do so as well. You can, if there's a financial attorney involved, you can possibly appoint an advocate. You might not be able to, if you're the health and welfare, if you're the financial attorney, you might not be able to appoint yourself to do that. But we have had situations where we've had solicitors who are financial attorneys who have stretched, I suppose, the definition a little bit by saying, I'm responsible for paying for the care, and so therefore I am responsible for ensuring that that care is appropriate. And we've been able to get in on that basis, and actually it's worked very well. But that depends on if there is a financial attorney, and it depends on how amenable they are. But it's always worth trying.
Thank you, Alison. And I know definitely I've tried that on many occasions and argued it successfully where I've needed to do. That is all we've got time for today. So really, thank you very much for attending. Thank you to our panelists for their insightful comments today. Hopefully you found it informative. Please take a look at our coronavirus hub. That's got quite a lot of information that we have created at this time. And also, please do make sure that you complete the feedback survey, including putting down any future topics that you might want us to discuss. And all it remains for me to say is thank you, and I hope you have a very sunny afternoon. I know Stuart will be going back into his garden.
Very much so.